When landlords first heard about the Renters' Rights Act, one of the biggest concerns for them was the loss of Section 21. But for me, one of the things that concerned me most was the way that we were to now increase rents. In this video, we're going to cover what increasing rent looks like post Renters' Rights Act. Hi, I'm Bennett, Compliance Director at Tenancy Management Hub. And in this video, I want to talk you through how rent increases now sit within our organisations following the implementation of the Renters' Rights Act, and what that means in practical terms for how you're pricing property, structuring deals, and protecting your landlord's income. Rent increases post Renters' Rights Act. Thankfully, no rent cap was introduced. However, landlords and us as agents must be able to prove that the rent is a fair market rent, both at advertisement stage and when looking to increase the rent during a tenancy. Tenants can challenge the rent amount that they are paying, even if they have accepted it by moving into the property. Transparency and accountability have increased for both landlords and letting agents to be able to prove that the rent that we are asking for is fair and just. The only way that a landlord can now increase their rent after the implementation of the Renters' Rights Act is via a Section 13 notice. Gone are the days where we're able to rely on clauses within tenancy agreements, normal negotiations with tenants, the good old conversation where we mutually agree an increase that suits both parties. All of that is now out of the window. So from a letting agency point of view, our administration, our responsibility and our liability surrounding rent increases have increased massively. There are new notice periods that need to be considered. Following Renters' Rights Act implementation, the notice period that we now have to adhere to is a 2-month notice. Rents can only be increased once annually, giving the tenant the right new notice period. Now, one of the biggest changes and the biggest concerns for landlords and agents surrounding Section 13 notices is the right to challenge the increase through tribunal that the tenant has now been given. Tenants prior to Renters' Rights Act were always able to take the rent increase to a tribunal if they felt that it was unfair and not at market value. However, one of the biggest changes that have taken place since the Renters' Rights Act came into force is that should the tribunal determine the rent is actually a fair rent, it will no longer be backdated to the initial start date of the proposed rent increase. The new rent will only be implemented upon the determination date of the court. What this means is tenants can raise a case with the tribunal just to delay the rent increase, even if it is fair. And one of the things that we need to consider as agents is that we now are going to have to evidence, document-based evidence, every rent increase that we're proposing to the tenant. So we're going to have to provide best price guides. We're going to have to show tenants that the rent increase that we're proposing is at market value or in fact below in some cases. As I say, this whole process has become now much more formal, much more document-based, and agents need to have adapted their processes in order to manage effectively. If you found this video useful today, please don't forget to subscribe to our Tenancy Management Hub channel for more content just like this.